Hello class, and welcome to this week's lecture. What we're going to be talking about in this lecture is an introduction to our court system. Just a basic understanding of kind of how it works. It's a great lecture to get us started in our class, so let's get right to it. Now, we're going to start right off with there are two basic court systems inside of our nation, okay? There is the federal courts, and then there are the state courts. All right. Now, each of them have their own styles of courts inside of the system. So we're going to start with the federal court system. Now, please keep in mind that this is not a highly tested subject. You maybe get one question on a midterm in regards to this, but it's a great foundational piece that you need to understand. So, federal courts. Now, for the most part, federal and state have three tiers, okay? The federal court has the district courts, okay? Appeal court, Supreme Court, okay? So, district, appeals, Supreme. Okay, the Supreme Court would be the highest court. Appellate court is the middle court, and the district court is the lowest court. So, the cases normally, not always, but normally start in the lowest court, which is the district court, okay? And if you do not like what your results were inside of the district court, you can appeal to the appellate court. If you don't like what happens in the appellate court, you can ask the national U.S. Supreme Court to hear your case. Okay, so those are the three steps. With the Supreme Court being by far the most important court in the land. It is comprised of 9 justices. These 9 justices are appointed by the president and confirmed by Congress, and, well, really it's the Senate, but here nor there. And they have a lifetime appointment, which is makes them a very, very powerful part of our government. Now, do you need to know all of the justices? No, but I have been known to throw a bonus question in now and then that says, name one Supreme Court justice. So, if you can name one, you probably would get the question right. So that is kind of how the federal court system is designed. Now, they have specialty courts as well. This is never tested, but specialty courts are things like bankruptcy court. That is a specialty court. There is a military appellate style court, which I've never been involved with, but if you're court-martialed, you have the ability to get out of the military realm and into the federal courts. And there's also international trade courts, things like that talk about trade with other countries. So that's kind of where the federal court system is, and the way it works is for us locally is we are in the Middle District Court of Florida. Okay, so our lowest court, our district court, is called the Middle District. Now, if you did not like what happened to you in your case, you would appeal to the 11th Circuit Court of Appeals. Okay, so the 11th appeals. So we're in the 11th. And that courthouse is located in Atlanta, Georgia. Now, if you did not like what happened to you in Atlanta, then you would ask for the U.S. Supreme Court in Washington, D.C. to hear your case. So that's kind of the federal court system. Now, the state court system, okay? The state courts. Now, the state courts, it changes a little bit from state to state, but for the most part, you have your trial courts. There's 3 tiers. The bottom tier is the trial courts. Middle tier is the appellate court. And the upper tier Supreme Court. So it's the same thing as the federal courts, except for the lowest court, instead of being called a district court like in federal, it's called a trial court in the state of Florida. So what we would be is we're here in the 9th Circuit, okay? So we would be that would be our initial court, okay? Then if we need to appeal, we would go to what's called the 5th District Court of Appeals. And then if we didn't like what happened there, we would end up in the state Supreme Court, which is in Tallahassee. So that's kind of the levels that we go. Now, just like they have specialty courts over in the federal system, there are specialty courts as well inside of our state system. It's things like probate court, juvenile court, dependency court, some different things. The veterans court, a lot of our counties have small claims, stuff like that. There's specialty areas, and those are included as well. But the three main tiers are the trial, appellate, state Supreme Court. So that's kind of I guess the best way I can put it is the hierarchy of them. So that's the court system in a real general type of mannerism. Now, a lot of times what we got to discuss is we have to discuss, how do you even start a lawsuit? What is a lawsuit? All these types of questions are very, very important, and they're highly tested. Okay, so this section that we're about to go over the next few minutes is tested. So make sure you understand these key terms. So the person who initiates a lawsuit is called the plaintiff. Okay, so that's the person who believes that they've been wronged. And the person to whom they are accusing is the defendant. Okay, so it's plaintiff and defendant. So if I'm the plaintiff, how do I actually get in front of a judge to recover damages for my loss? Well, it starts with what's called a complaint. So a complaint is the first document filed in a lawsuit. A lot of times you'll see the word initiating a lawsuit through a complaint. So that's how you initiate it. It's how you begin it. So you file a complaint. So what's a complaint? It's actually a super simple document. Now, a lot of ones that attorneys write are extremely complex. However, they don't have to be. The only thing that the complaint really needs to state is why you're there. Like, what happened, judge? This is why I'm here. This is what I'm suing for. And what you want. So, say you are a hotel owner, okay? And you had a order of pillows, for your beddings. Okay, so you ordered 1,000 pillows. And you get the pillows, and you ordered the firm pillows, and they come out, and they're the Snuggie Soft pillows. And you're like, we don't want Snuggie Soft, we wanted firm. You call the pillow manufacturer, they're like, we're sorry, but we're out of firm, and you're just going to have Snuggie Soft. And you're like, we want our money back. And they're like, nope, sorry, you already opened the packaging. And we won't return them now. Or we will return them, but we want a 15% restocking fee. And you're like, whoa, you sent me the wrong thing. So you would file a complaint in your district court that would say, District Court, I bought super firm pillows. They sent me Snuggie Soft pillows. They won't give me my money back. I want my money back. X number of dollars. I paid $1,000. I'd like my $1,000 in return. That is what a complaint is. Okay? So you're telling the court this is the issues that I have. Now, the defendant has to know that there is a complaint has been filed against them. A lawsuit's been filed. So that's the second step. First step, complaint. Second step is what's called service of process. So if you've seen in the movies or anything like that where someone walks up to them and go, hey, are you Joe Schmo? And they're like, yes. And they're like, well, here you go. You've been served. That's what this is. So a process server is the person who would give service of process to a defendant. And that service of process, the number one thing in there is the complaint. It tells the defendant what complaint has been filed against them and then gives him a certain amount of time to answer it. In most cases, it's 20 days. So the defendant now has a chance to say, oh, Hotel X has, sued me over these pillows. So now you have a chance to respond. And that response is called an answer. Okay? So the first paper is a complaint, and then that is served upon the defendant. And the defendant has X number of days, depending on the lawsuit, to file an answer. Okay? Now that answer can tell their side of the story. It also doesn't have to, but it can include a counterclaim. They could say, hey, no, we didn't return it because they still owe us $500, whatever it is. it doesn't, whatever their beef is with the hotel, they can put in their answer. So they can sue them back. Be like, okay, you sued me for this, well, I'm suing you for that. That is kind of what an answer does. So, I mean, that's the beginning of it. So we got our two parties, okay? So we got the plaintiff and we got the defendant. Now, who else is involved? Well, obviously, the judge is the third person involved in this case, okay? And the fourth entity that gets involved is the jury. Now, not all cases have a jury. Some do, some don't. And there's no reason to get into the differences between them. But there are two types of trials. There's a bench trial. That's where the guy sitting on the bench or lady sitting on the bench makes the decision. That would be a judge. Or there's a jury trial where, a group of our peers decides the outcome of the case. And the judge just kind of referees, decides what evidence comes in, and make sure that everything is moving smoothly inside of the trial and everyone's following the rules. So those are the parties. So we've talked about the parties. We've talked about how we file a lawsuit. Now we file the lawsuit. The guy's given his answer. Now what happens? We don't go straight before the judge and jury at that point. That is not what happens. The next process, okay? The first process is starting the case with our complaint and our answer. Now, there is a word that is used to define both the answer and the complaint. It's called the pleadings, okay? It's called the pleadings. So we've got the pleadings. The next process is called discovery. Now, discovery is where the parties have an opportunity to learn more facts about the case, okay? So, say for instance, the pillow manufacturer says clearly in our contract that if you open up the pillows, you have to pay a 15% restocking fee because we have to restock them. So if you don't like the fluffiness of the pillow, you can tell that inside the packaging. You don't have to open the packaging to see if it's a firm pillow or a super soft pillow. Okay? Then the plaintiff has the opportunity to say, well, I don't have a copy of the contract. I know I docu-signed it over the internet. In discovery, you can get a copy of that contract. Okay? You can also do two things I want you guys to kind of write down and know. Two devices. One is called a deposition and one is called an interrogatory. Okay? Deposition, interrogatory. A deposition is normally done verbally. So that is where someone comes in and they are sworn in, it's under oath, and the attorneys are allowed to ask that witness or party questions. And they have to answer them. And whatever they say inside of the deposition, obviously they have to say in court as they are under oath, okay? So it's that whole thing where they go, were you lying then or are you lying now? So you got to say the same things. So the deposition is of a party, so of the plaintiff or defendant or a witness. So say, for instance, the plaintiff, the hotel, says, we didn't open your pillows. They were already open when we got them. And they have a witness to it. An independent person that has nothing to do with the case. He's the UPS driver who was there, and the hotel manager said, hey, hold on. Before you leave, I just want to make sure these are our pillows. So he opens up the box and grabs a pillow, and a pillow falls right out of the thing onto the ground. Obviously, he didn't open up the cellophane. It just fell. Well, that UPS driver is a witness that says, oh, he didn't open it. They weren't closed. So that witness gets deposed to hear his side of the story. Okay? Or a party can be deposed. Now, the second one, interrogatories, are a little different. They are normally, they're always in written form, and they can only be of the parties. So only the plaintiff or the defendant have to answer interrogatories, not witnesses. You have to depose witnesses. So it's very common to see on an exam the question of, it's almost like not a trick question, but they'll say, can you serve interrogatories on a witness? And the answer is no. Okay? Can you serve interrogatories on a party, a plaintiff, a defendant? Yes. Okay, so that's kind of what you got to know the difference is depositions, anybody, interrogatories, only parties. So that's the main part of discovery. So now after you've done discovery, you have the opportunity to, there are motions that are filed and people trying to exclude evidence and all that kind of stuff. We don't need to get into all of that for our purposes. But the next part after discovery is the trial. Okay. So trial, there's a fancy word. It's called voir dire. Okay. Voir dire. It is jury selection. Okay. So I can tell you something about voir dire. The spelling of it is V-O-I-R-D-I-R-E, voir dire. Okay. Now I like Latin terms. They're very important inside of the law. So I would make sure if you ever hear a Latin term or you read a Latin term inside of your book, make a note of it. I commonly test on them. Sometimes they're the wrong answer, but I like to put them in there. So the first thing we do is we select the jury, okay, if it's a jury trial. So the jury gets selected. So we've picked our 12 jurors, right? The next thing that happens is opening statements. So each side, the plaintiff goes first, has the opportunity to speak to the court, speak to the jury about what they're going to see in the trial, okay? And then the defense has the opportunity to do the same, to go through and give a basic synopsis of what they're going to explain inside of the trial. So that's the first thing that happens. Then we get into the examination of witnesses. So the plaintiff goes first. The plaintiff will put one of their witnesses on the stand, all right? And they will do what's called direct examination. I would make sure you know all of these steps. It's highly tested, okay? And the order of them and all that kind of stuff. So know this. Obviously, watch the video multiple times, especially when I tell you to know something, okay? Pause it, rewind it, write it down. So the plaintiff goes first, puts his witnesses or her witnesses on, and that's called direct examination. So that is the questioning of your own witness. When they are done, the defense can cross-examine them. So that's where the defense gets to ask them rebuttal questions about what the plaintiff had asked them previously. That's cross-examination. So the plaintiff gets to call all their witnesses, okay? And then at that point, now the defendant gets to call their witnesses, okay? So the defendant puts their witnesses up on the stand. Now, it's their witness. So it's the direct examination. So when the defendant's attorney is questioning the defense's witnesses, that's direct examination. Then the plaintiff will get to do the same thing and cross-examine the defense's witnesses. Okay, so that, basically goes through, and then we get into closing arguments. So after we've got all the witnesses out, now is the opportunity for the plaintiff and the defendant to basically explain to the jury why they should side with them, or the judge why they should side with them. It's their last chance, okay? Now, there are some motions and things like that you may see in your text. You should know what they are, obviously. Anything that is defined in the book or is a red word or a black word with an underline, it's a definition in the book, you need to know it. But there are many motions that happen inside a court. But what I really want you to know is it starts with jury selection, then the opening statements, then the plaintiff's witnesses, then the defense's witnesses, then closing statements. That's the big, meat area of, what we need to know. So, as we go through, and we've kind of, talked about the way it works, is now all that's happened. The judge or the jury makes a decision. And that decision, obviously, is what we use to determine the outcome of the case. So then the judge decides who wins, who loses, and what the penalties are. Okay? Or the jury, potentially, depending on what kind of trial we have on our hands. So that's kind of the introduction to our court system. I wanted to make sure we had a good grasp of that. And now we're going to go into alternative dispute resolution. Okay. Now this is important for all areas of law. Okay, because there is a substitute, I guess you could say, for going to trial, and it is called alternative dispute resolution. Incredibly important. Okay, to our court system. Like this is if we did not have this, our court system would be a complete mess. It's already very difficult to get into trial. People don't understand this, but I mean, it can be a year and a half before you get into trial. It can be that long. Just we're very, very backed up. So we have devices in place that give us the opportunity to solve our case without needing to go to a trial. Now, there's several reasons why alternative dispute resolution is valuable. Probably the two most important ones is one, cost. Okay, a trial, average cost, $20,000. That's what it costs to go to trial. To do alternative dispute resolution, couple thousand, $2,000-3,000. Much cheaper than the $20,000 that it costs to go to trial. Because you got to remember, in trial you have all these depositions and interrogatories, and it takes a year and a half. It gets very expensive. Okay. The second thing that is a huge advantage of alternative dispute resolution is timing. Okay. So say we're in the hotel and we're having the discussion over the pillows. Well, mediation, we can get in tomorrow. Yeah, that fast. I mean, it can happen really, really quick. So it's a great opportunity where two parties don't want to fight for a year and a half and spend all that money. They have the opportunity to go into an alternative dispute resolution like a mediation. So let's talk about different forms of alternative dispute resolution. And I got a few of them in front of me, so I'm going to speak about each of them. The first one is arbitration. Okay, now this is a big one in law. So basically what it says is binding arbitration is like a little mini trial. I mean, it's fast. There's an arbitrator who's kind of like a judge. A lot of them are former judges, and they relax a lot of the rules. So when we go into trial and you hear all these objections and this and that and all the motions that you kind of, you've read about, throw all that stuff out the window. We don't do that in arbitration. In arbitration, state your case and let's get it done. It's kind of the way it works. It's very fast, much cheaper because a lot of those discovery devices we don't use. And arbitration is very commonly put into contracts for major corporations. So to give you an example, the pillow manufacturer, okay, probably has a clause in the contract with the hotel that requires arbitration, okay? And there's no way around it. If it requires arbitration in the contract, you got to go to arbitration. And major corporations do that because they're tired of paying $20,000 on every complaint. So they have binding arbitration. So instead it costs them a couple $1,000s, not 20 a complaint. So they put that in contracts. So if you're in the hotel industry or the food and beverage industry or you're in the rental car industry, it doesn't matter. You'll probably notice in the contracts that your company has where it has an arbitration clause. And it'll say binding arbitration. And those are enforceable and they're very common and they are good in the sense that things get done much quicker for everyone. Now, for the consumer, they're not as great. And that's why big corporations put them in there. Because the consumer doesn't have the advantage of being able to settle the case based upon money, like a time money algorithm. Because here's the thing. Okay, say I buy the pillows and I bought $5,000 worth of pillows. And we're talking about a 15% restocking fee, okay? Well, that would be $750, I think. Anyways, be $750 would be 15% of $5,000. Well, if you could take them to trial, they had to spend $20,000 to save $1,500. Okay? That gives the consumer the advantage because they just write checks then. They just settle because they don't want to spend $20,000. It doesn't make mathematical sense. But they may be willing to spend $1,500, $2,000 over a $1,500, $2,000 art dispute because the money's about the same and they're proving a point. They'll take that. I mean, that's fine. Break even. No worries. So it helps reduce the amount of frivolous claims for people who don't really have a case. They're just playing the odds that the other side doesn't want to pay the money for trial. So that's arbitration clauses. The second one is mediation. By far the most popular alternative dispute resolution because it is very quick, very inexpensive. Most mediations, a couple $100. Okay, $200-$300. They have all kinds of ones. There's companies, I'm not saying the Better Business Bureau, but just for lack of the knowledge of exact ones. So these groups like that, they offer, mediation. Some of them are even free for disputes because they're trying to help the businesses rectify issues. And mediation is great. Now, mediation is different. Mediation is not binding, okay? Mediation is just an opportunity to try and solve a problem with a professional mediator. Mediators don't make decisions. They're not judges. What they do is this is what I'm a Florida Supreme Court mediator. Okay, so I'm a legit mediator. Okay, got the certificate on my wall and everything. And what I tell the parties is my job is not to adjudicate their case. My job is not to make any decisions. My job is to provide options to the parties to empower them to resolve this on their own. Okay, that's what I tell every one of them. And that's really what we're doing. What we're doing is we're taking it out of the judge's hands, taking it out of the jury's hands. Okay? And we're going to let the parties decide what they want to do. Now, if they can't come to an agreement, they do what's called impasse. Okay? IMPASSE. Okay? Impasse. And that means they did not come to an agreement. And now they got to move on to arbitration or trial or do whatever they want to do. But they didn't come to an agreement. Now, if they come to an agreement, we write up a settlement agreement. And the one party pays the other party or whatever the case may be. Case is over. A few $100 and you're done. And we figured it out. And it's a great device. Quick, inexpensive, you get to make the call. Those are three very, very, very good things that mediation does. Another thing about mediation is confidential. So anything you say in mediation can't be brought up in trial. So I'll give you an example. We're the hotel, and we're doing mediation, and he says, and I say, yeah, the pillows were open. The cellophane was open. I didn't open the pillows. Well, I didn't open all the pillows. I mean, I opened a few of the pillows. Okay, I opened half of your dumb pillows, but that was only after I noticed the other half weren't open. And that guy goes, well, you opened half of them then. So you can't get a return on half of them, the ones you return. Okay, and we get in a big fight and mediation doesn't work. He can't go to trial until the judge would have said. Nope. Everything I say in mediation is confidential. So there's no, but he said in mediation, judge, that he opened half of them. Mediation is confidential. Now, depositions, like discovery, remember from back when we were talking about, if I said that in a deposition under oath in front of a court reporter, I'm stuck with it. In mediation, it's confidential. A couple other ones that are pretty common. One is called rent-a-judge. Okay, so that is where we hire a judge to hear the case on the side because we want a real judge. But we don't want to wait a year and a half. And we got money. So the hotel and pillow manufacturer, they got the cash to pay $5,000 for a judge to hear the case immediately. Well, they don't care. And they're big, huge corporations, whatever. We pay another $5,000. And they can rent a judge. And that is a lot of times, it can be cheaper because you get rid of a lot of the timing of it and all the emails and all the phone calls and all that kind of stuff. And sometimes it's just the cost of doing business. I mean, so the hotel and the pillow manufacturer, they want to do more business together. They just have this one issue. They need to get past it so they can buy and sell more stuff. So they rent a judge. That's very, very common. It's also known as like a mini trial. Can be another alternative dispute resolution. A mini trial is where we're just talking about one particular issue. If we could just solve the one issue, everything else would go on itself. Those are also very common. Expert panel is common as well. So using our same hypo of the pillows, and the question would be, is it normal for the pillows to be closed and not open like the cellophane? Okay? Well, you get an expert panel. So you would get 4 or 5 pillow manufacturers that are not in this discussion and find out, is it reasonable to even do that? Or the clause in the contract that says, hey, if you open them, you got to pay a restocking fee. Is that industry standard, or is that some nonsense they threw in there that is not reasonable? An expert panel can help us tell us that. So that can be a very, very good one as well. And I guess the final one would be a summary jury trial. Now, a summary jury trial, these are not done very often at all, but they're very interesting. I've never even done one, honestly. I know a few people have done them, and I've suggested them a couple times, but it is where we actually hire a judge, okay, or maybe not even a judge, maybe just a seasoned attorney, and we pick a panel of 12 random people. Okay, they're not attorneys, just 12 random people off the side of the road, and we pay them all minimum wage to come in and hear our trial, to hear their openings, my openings, our closings, a little bit of our testimony, and we let them actually decide, like they were a jury. And then the attorneys get to hear, how does the case play out in front of a jury? And if it's 12-0, say the plaintiff wins 12-0, all 12 jurors say, the pillow manufacturer's wrong. Well, the pillow manufacturer might be like, okay, I'll settle. It's over. It's good. You get your money back. I don't want to go through it. Obviously, our case doesn't play well in front of juries, and that can happen. But that is kind of what a summary jury trial is. So where we're at inside of this particular lecture is this is kind of an introduction to the law, an introduction to the court system, and an introduction to alternative dispute resolution, which is clearly a very, very important thing for anybody that is moving into any area of business. It doesn't really even matter which field. These are applicable to everything. It's applicable to, even outside of just the law governing our businesses, say our family lives. So if we were getting a divorce, same process. Somebody files a divorce petition, a complaint. The other party answers it. They do discovery. They go to trial. Or they go to mediation. Talk to a mediator. Mediation actually is not, it's always a voluntary process in the sense that you don't have to share anything and you don't have to agree to anything. You just got to show up and listen, okay? You got to go in good faith. But a lot of cases require mediation. Judges order it. So I would say 70-80% of my cases, a judge will get to the two attorneys and say, hey, you guys are going to mediation whether you like it or not, because you're not getting into trial for a year anyways. So let's send you guys the mediation and let's see if you guys can't come to a settlement and get it off the court's docket. Happens all the time. I don't know the actual percentages, but well over 80%. I know I've heard the numbers a million times. It's always over 80. Actually settle in mediation. So it's extremely common for mediation to be successful, because mediation is a great opportunity for the parties to get into a room with someone that can help them build options, talk about the law a little bit, and a lot of times mediation, will be months after the fact of what happened, and people have had a chance to kind of calm down from the situation, and a lot of the emotion is no longer in it, and we're able to think clearer and just make a business decision, not make a decision on emotion, but instead on the financial aspects of the case. So that does it for our lecture, Introduction to the Courts in ADR. Make sure you take good notes, and we will see you next time. Thank you.